Hello, legal-minded friends. A question I get all the time is, wouldn't it be nice to see the courts in England? Sadly, I cannot take you inside our courts because it's not allowed. However, I did find the architects online who have shared photos of inside, so you can see a view of what the courtroom looked like. But what I can do is share my walk to court. And recently I was in the city of Bristol. They are the 10th largest city in the UK and the second largest city in southern England, famous for, among other things, the Clifton Suspension Bridge. And in this members only video, I share a gruesome criminal story of what they found under that bridge, alongside a really nice story. So I've been away the last couple of days working on a civil matter, and I'm just watching the hearing that took place in Aidan Kearney's case, dealing with allegations of being in a conspiracy with Karen Reid to interfere with witnesses in her trial. And I wanted to share my take on what happened. Have you heard the phrase, if you don't ask, you don't get? Well, that's the way I view search warrants. Police need to ask a court for permission and obtain a court order that allows them to look for and seize something from a suspect or a person of interest in an investigation. Now, I'm not being flippant when I say search warrants, in my view, are like, if you don't ask, you won't get. In the UK, for example, over 40,000 search warrants are issued in England and Wales a year. And in 2016, a review by the National Crime Agency found that 79% of investigators had defective warrants, of which 8% had significant deficiencies, like false allegations and inadequate safeguards protecting individuals' personal information. And we're going to hear about this, as this was factored into the search warrant regarding Karen Reid's phones. So let's talk about search warrants, and we will review the recent hearing in the Aidan Kearney case, where Karen Reid's attorneys requested her phones back. And this opened up a confusing discussion with parties and the judge. Let me just quickly look at the background from the bail conditions, as I thought there was something interesting. They referred to Aidan Kearney as the defendant, who is a local blogger and activist who operates a number of websites and social media accounts under the name Turtle Boy. I'm not sure why they haven't referred to Turtle Boy as an independent reporter and journalist, which he has credentials for. So why do you think that is? Don't reporters ask the tough questions? So at what point does it become witness interference or intimidation, or a conspiracy with Karen Reid? And this is serious, people, because Turtle Boy, if found guilty, could face 106 years in prison. That's mind-blowing. So what's kind of going on? Karen Reid's phones were seized to secure evidence. The allegation is that she was part of the conspiracy with Turtle Boy, feeding him evidence obtained in her trial to interfere with the Commonwealth's witnesses. The court granted an order for a search warrant to only seize her phone in January 2024. The warrant was to have the data copied only. Downloading needs specialist tools or a password to unlock the phone. The details of this search warrant stipulated that the search of the data would need a further warrant or court order, and no search of the data would commence until a taint team could search, because there is an expectation of privacy. Remember, we just said that was one of the concerns in England. So, there's this expectation of privacy in our cell phones. So that taint team is asked to search the cell phone data. They are an independent party who separates out personal information or personal conversations, photos, or other evidence that is protected by attorney-client privilege, for example. So let's watch the hearing to find out what's going on. I will play the hearing, adding notes on the screen if needed, and stop to comment on points, give you my take or understanding, or just add something that might make it a little bit more understandable. Well, we don't have to wonder any further as to why the Commonwealth isn't bothered that Aidan Kearney, Turtle Boy, is a bona fide journalist, because in the state of Massachusetts, they don't have protections regarding their source material. So I found this little clip from The Young Jerks on his YouTube channel. He's played the full hearing, so go check that out. However, there is no protections for journalists, and this is why a taint team is needed. However, the government is arguing that this is not privileged information. The sources that a journalist, the conversations that a journalist has with their sources. So let's have a listen to that.
Is that, and I'm not necessarily opposed on principle to making new law, but I think I'm correct in saying that if the court rules that the taint team screens for anything other than attorney-client privilege, it would be the first case I am aware of in the United States that has ever had that holding. And I think it would also be the first case where the so-called qualified journalist privilege has not yielded to the demands of and the interests of the government in terms of vindicating search warrants and criminal law.
Go check out his channel to watch the full clip. So I hope you thought that was interesting, that journalists have no protected rights regarding their source information. So now let's get back to the hearing where Karen Reid's attorney is discussing the return of her phone and has a dispute with the amount of time the prosecutor has had her phone and they haven't downloaded it.
All right, let's deal with Mr. Buzang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0004, but it really is a request for setting a set of conditions for searching through Ms. Reid's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reid's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
So what I'm going to do is I'm going to speed it up a bit. So if you want to slow it down, just go to the little settings cogwheel in the top right corner, and then you can slow it down or speed it up. So basically, the court has told us that he thinks he's, this hearing, he's called this hearing, and it's to set up a protocol on how they're going to search the phone, because he's already ordered that the phone was seized, the phones, and then, he's saying that included in that order, it was to download the phones. What the wording I saw was to copy the phones. So that's what the judge thinks has happened, and now this order is just the next stage of it to talk about how they're going to look at that information.
What the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay. I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth having been in possession of the phone for an extended period of time has a finite amount of time in which it can seek authorization to search. or to do the search. Let me just see for a second.
So what's happened is, at first I was really confused, and then because I thought that if it was downloaded, then the police have an unlimited time to search the phone, provided, the case is still being investigated and stuff like that. There are some occasions where a phone might not even be returned back to the person, for example, if it's stolen or something. But what the judge is just cotton on to is that he made an order and it hasn't been executed completely by the police, which is different because, for example, in the UK, police have 3 months. And when I looked up the Massachusetts laws, this came up on the government website, and it was something that I could click into. So basically saying that it's about 7 days that they have. But I did read in other places the judge can make a ruling on how much time they have to execute the warrant. So basically that's what's happened is they've had a warrant to seize, which they did, but the warrant also included to download the information and then to wait for a protocol before examining that information. So it looks like they haven't executed completely what the order was for them to do. And it does seem like they've waited a long time. I mean, you can read on the screen how they're supposed to count the days. But the other thing is, it should be completed by the officer who executed the warrant. And so what it sounds like is that it wasn't executed within the a reasonable amount of time, right? And that's what the defense is complaining about, and they want the phone back. They're saying, look, it's been far too long. And then we're going to hear some arguments about that in just a second. 15 moments later.
Yeah, so in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No,
they haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the log-on information or the receipt of the passcodes.
Okay, well, so you've been in possession of the phones since January of 2024 and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is a practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol. As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Okay, so the way I see it is that they've, in a way, breached the order to download because they didn't do it in a reasonable time period. And so now the judge needs to decide on that. And let's hear what the judge has to say.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right. The case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawful...
Okay. So what he's saying is that there has been reasonable delay in that they do not have the passcodes to actually download the phone.
U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that...
So he's basically saying because they've got the seized items, that's their burden now to prove why the delay has been a delay. And they're saying it's been a delay because they haven't got the passcodes. And they're allowed to keep seized items as long as they want, provided the investigation is still open. So I'm looking at it differently. I was looking at it like the court ordered the download. So I'm kind of looking at it the same way the defense is looking at it. It was an order to do something. So anyway, let's continue.
Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, right. Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that results that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones, or any other piece of evidence. You know, a warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment and Article 14 of the Search and Seizure Law requires law enforcement to act diligently to obtain a search warrant and without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case.
Let's talk about that. The defense attorney cannot cite a case speaking to exactly what the judge is asking for. That deals with a search warrant that has been ordered by the court to do a download, and then there's been a delay. So the defense attorney doesn't have one and is now relying on the Constitution, specifically the Fourth Amendment, which protects U.S. citizens from unreasonable searches and seizures, requiring warrants to be judicially sanctioned and supported by a probable cause, which is a reasonable basis to believe a crime has been committed. And this is why it's important, because I had the same question. Is the search warrant overreaching to use as evidence in Turtle Boy's case in light of, the grand jury? They already have all Turtle Boy's downloads and everything. Here, I've got a screenshot of that for you. So a no bill return means that the grand jury did not indict a person because they found insufficient evidence to believe a crime was committed or suspected of a crime. And that's really important, because what I want to do now is play Turtle Boy himself telling us how the police got this idea that Karen Reed was conspiring with him. So let's have a listen to that.
At that interview, on the December 14th interview, is where she gave Brian Tully these allegations that, Turtle Boy and Aidan are, Karen Reed and Aidan are, talking all the time on the phone, and she directs him what to say, and she bought him a Lexus, and they subpoenaed my bank records over there. It was just such nonsense. That's all they needed to get the warrant, is they talk on the phone, and they're saying that Karen Reed directs Turtle Boy what to say. That's what Natalie said, and then Lindsay repeated that, and then they got a warrant. That's literally all they need. They could have got that without. Lindsay didn't add a single thing that Natalie hadn't already said at her October 14th interview.
So this is my take from what Turtle Boy is saying. The search warrant was based on false information that was repeated by someone else. Now, this is my opinion. There must have not been anything nefarious or criminal activity going on Turtle Boy's phones between him and Karen Reed. Because if there was a hint of him getting evidence from Karen Reed, there would be a digital trail on his devices. And that's what his lawyers were saying. And clearly the grand jury did not feel there was enough evidence to indict them. So are we to believe they went to a grand jury before they made any efforts to search Karen Reed's phones when they didn't have the passcodes? Why continue to want information from her phones after the grand jury's decision? Why wait so long to seek an order from the court to search her phones when they needed the passcodes? What changed? It sounds like a fishing expedition. And the court came full circle from when he started. He said the hearing was to set up a protocol on who would search the phones. That, in my mind, says that he had already made up his mind. He told the parties to mutually agree who they would want to search the phones. That's how he ended. And he also said to the defense, if they found case law that specifically speaks to this situation that they are in, meaning they have an order to seize the phone and download the phone. It's just the delay that is the problem. So he's basically saying, the parties would have to work together on a protocol, which sounds like the judge will accept. They didn't have Karen Reid's passcodes. And does this also mean if Karen Reid does not provide her passcode, because remember, you don't have to provide your passcode to the police, and there's no order for her to provide it. So would the next step be that the court will compel her to give her passcodes? And then what if she doesn't? Will there be a contempt hearing? This makes me wonder why the Commonwealth is so keen on getting Karen Reid one way or another. So what's your thoughts? Do you think police should be able to get a probable cause search warrant to download information when the information has come from people who may have an axe to grind? And this is what Turtle Boy was talking about. There was 2 people that gave information to the police, and one of them was friends with Karen Reid, and they fell out. So there may be, ulterior motives that why she was saying that Turtle Boy and Karen Reid were conspiring together, and that she was giving him information. So, and the other person, it was hearsay, and, she didn't have actual knowledge of it. So if you've been following the playlist that I've done on the conspiracy to commit the unaliving of Dan Markel, in that playlist I go through conspiracy, and with a conspiracy charge, hearsay does come into play. So that is why the police have taken the hearsay statements of others seriously. Though that does not address why there was such a long delay in downloading Karen Reid's phones. So I think this case will be really interesting going forward. What's your thoughts? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.